Welcome to the March 31st, 2026 Commissioners Meeting of the New York State Public Campaign Finance Board. I'm Barbara Lifton, Chair, and I'm joined by Vice Chair Brian Cole and Commissioners Keisha Gaskins-Nathan, Henry Berger, Esma Bagnola, Anthony Casal, and Peter Kuczynski. I think maybe there's a few staff in the room. If you'd please go around and introduce yourselves. Let's start over here.
Brian Keegan, co-director of PCFB.
Kristen Zabrowski-Stavisky, co-executive director, State Board of Elections.
Tom Connolly, Deputy Executive Director, State Board of Elections.
Skylar Conyer-Kinnaman, Deputy Enforcement Counsel, PCFB.
Mark Statinger, Deputy Counsel, PCFB.
Jennifer Olson, Deputy Director of Public Information.
Kathleen McGrath, Director of Public Information, State Board of Elections.
Brendan Lavello, Co-Executive Director, State Board.
Bill McCann, Co-Counsel to the Public Campaign Finance Board.
Raymond Riley, Co-Executive Director, New York State Board of Elections.
Carl Zimmer, Co-Director, PCFB.
Aaron's here.
Co-Counsel, PCFB.
Thank you all. Having no old business today, we will move to new business right away. We have 4 resolutions to consider. The first A on the agenda, Resolution 2026-04. Final adoption, the amendment to 9 NYCRR Subtitle 5, Part 66221, related to the Public Campaign Finance Program, related to 24-hour notice. I'd like to take up that resolution. Do I have a motion?
So moved.
Thank you. A second?
Second.
Thank you. All in favor of this resolution, say aye.
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 Any opposed? Thank you. Unanimous vote, 7-0 on that resolution. The second resolution B, Resolution 2026-05, final adoption, amendments to 9 New York CRR Title 5, Subtitle 5, Part 6, 2021, related to the Public Campaign Finance Program related to enforcement. I would like to take up this resolution. Do I have a motion?
So moved.
Thank you. A second, please.
Second.
Thank you, Esma.
Commissioner, I'd like to speak to this resolution if I could.
Yes, thank you, Peter. I was just going to ask for discussion.
Okay, great. Yeah, I have a little bit. Wait, this is a final adoption of an emergency regulation that was brought to us back, I believe, in December. And I objected to it at the time. Specifically, it's the last paragraph of this proposed regulation. And I'll just read the pertinent section. It says a penalty above the standard amount may be issued if the violation is found to have been willful. I objected to that language last time because I feel that that standard of willfulness is far too vague. And frankly, it's something that I don't believe our staff or this board is capable of determining whether or not a particular candidate or committee has had a willful violation. I think if we adopt this standard, it sort of subverts the entire scheme we've put in place, which is to have a standard amount of penalty assessed to specific types of violations. I would be, as I mentioned last time, in favor of something that if we have repeat offenders where people have violated the same section of law over and over again, that I would be in favor of accelerating the penalties. But I think this willful standard is simply something that isn't enforceable. I think it requires testimony, it requires state of mind. I think that's something that typically is resolved in a court of law. And in fact, I believe in our statute, the willful standard is something that's assigned to the misdemeanor. So that if someone is a willful violator, it kicks over into the criminal statutes. And that is the appropriate resolution of that kind of activity. That would be something that would be done in a court. So I am objecting to this. I plan to vote no.
Thank you, Peter. Any other discussion on this? Peter's concerns?
May I respectfully disagree with my friend?
Yes, sure, Henry.
The willful standard is used throughout the law. And I think we certainly need to have the flexibility when such circumstances arise to make that determination and assess additional penalties for people who are willfully, knowingly, often part of the same standard, part of that measurement, are violating the law and are violating our rules. And I think this regulation gives us the flexibility, the necessary flexibility to do that. So I'm going to vote yes on this.
Thank you for your input, Henry. Anyone else have anything to say on this resolution? Okay, let's take a vote on this. All in favor of this resolution, please say aye.
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 Any opposed?
No.
Nay.
Is that am I hearing unanimous there? 4-3? Are we at 4-3?
I'm a no. I'm a no.
Okay, thank you. The motion carries 4-3. Thank you. On our agenda, C, Resolution 2026-06, final adoption, amendments to 9 New York CRR, Subtitle 5, Part 6221, related to the Public Campaign Finance Program, related to the Office of Governor/Lieutenant Governor. I'd like to take up this resolution. Do I have a motion?
So moved.
Thank you. Second?
Second.
Okay, thank you. Any discussion on this
Yes.
resolution?
Yes.
Yes, Brian Cole.
A couple things.
Sure. Co-chair Cole.
Brian's great.
Brian's great.
Okay, I have a couple questions. I'd like to direct them to Co-Director Carl Zeilman. I'm curious, did the PCFB receive any public comments regarding this regulation after it was adopted on an emergency basis?
Yes, Commissioner, the board received 2.
And who are the comments from?
We received one from Elections Attorney Adam Fusco. Second from the prominent public policy group, the Brennan Center for Justice.
And can you briefly summarize what the comments were from them?
Mr. Fusco's comment encouraged the board to promulgate a new PCF 22 form to accommodate 2 candidates. The Brennan Center for Justice sent a 5-page letter with which suggested amended regulation language that the PCFB must notify candidates of specific joint filing requirements in the cases of governor and lieutenant governor. Given recent reports of the potential partisan vote today, the Brennan Center recommended either accepting current gubernatorial candidate certifications as is, or provide them with a fair one-time 2-week cure period. We will ensure both of these public comments are posted as part of today's meeting materials.
Thanks, Carl. Seems like a couple good points that have been made. The PCFB has a mission to help candidates get into the program. The Brennan Center offers 2 fair possible solutions that would allow these candidates to submit what is required without being penalized by last-minute changes that were not only not adequately, but not communicated directly to any of the gubernatorial candidates that had already filed and were already accepted into the program. And to be clear, Carl, the regulation up for final adoption now, this is the same regulation that required the board to create the joint PCF form.
Agreed, yes.
PCF 22 form.
Yes.
So I understand that the previous resolution had agreement to reauthorize for emergency purposes. And I also understand the resolution is now being added to confirm that and for final adoption. However, I don't think we should be, we should be reauthorizing this regulation until and unless the staff creates the form for joint filing required by the regulation. The board also has a responsibility to do it when it was originally adopted, and the board failed to do so. The failure is part of the reason we are dealing with the next item on the agenda. It would be irresponsible to do anything less. I am moving to amend the resolution to state it be further resolved that the staff shall take no action towards reauthorization of these emergency regulations and take no action. Excuse me.
Sorry.
I second the motion. I'm not finished.
I'm sorry.
Until the staff produces and publishes a form for the purposes of joint filing for the joint office of governor and lieutenant governor. Said form must contain instructions on how to comply with the regulation and provide space throughout the form for multiple candidates to complete.
In that case, I definitely second the motion.
Should we continue discussing or do we have to? Yes, okay. So, so we have to take up this amendment and vote on it. And we have a motion. Do we have a second? Yes,
Tony,
Tony, Mr. Cassell was the second. Okay, so I call for a vote on this amendment to the resolution.
Can we have some discussion first?
Oh, yes, sure. Yes.
I think it's
Yes,
helpful.
please, Mr. Berger.
Yeah, I was pleased to receive the Brennan Center proposal yesterday after the last day for comments to be submitted. I think it makes some interesting points. I think it leaves us with two alternatives. One, we can fail to adopt the rules, in which case the emergency rules continue in force and effect. Or we can adopt the rules and going forward, look at their suggestions and come back and maybe make some future amendments to it. I don't think, as a matter of order, that the amendment is appropriate on a motion to adopt the rules. I think that motion may be appropriate when we consider the next item on the agenda, but I don't think it's appropriate here. And I'm going to vote against the amendment because I think our two alternatives are either adopt the regulations or not adopt them and let the emergency regulations continue in force and effect. Thank you.
Any other discussion?
I would just challenge Henry's, assertion here. I think our option is to adopt the regulation with the amendment and that way adopt the resolution. I don't think we have just a no, don't adopt it or adopt it as is. I think if we approve the amendment, then we could adopt the resolution with the amendment. So I think that's a third option that exists.
No,
Mr. Berger.
Commissioner Kozinski, I think if we do what you're suggesting, what we're doing is we're adopting a resolution and then saying we're adopting the resolution, but don't apply it, don't enforce it, don't do anything that the resolution says we have to do. And that I just can't agree to that. I'm going to vote against the amendment.
Yes, I would disagree with that, Henry, only in the sense, am I recognized? I'm sorry.
Yes, Mr. Cassell,
Yeah,
please.
I would disagree in the sense that what the Brennan Center is saying is we have not really promulgated fully the regulation. We already passed on an emergency basis in the sense we didn't create the form. So they're asking us to correct a problem that in essence we created as a board and as staff.
The form exists and at least one other campaign has properly submitted it. But the form has existed, does exist, and continues to exist.
that no one knew about. The PCFB campaign staff or the staff did not create the form. They didn't advise all the other gubernatorial candidates that this form was created and they had to resubmit it. They weren't notified, and this is after the PCFB had already accepted their application to the program. And that's the responsibility of the staff and the board to notify the candidates that had already filed and already been accepted by the PCFB. This is an abomination of trying to do bureaucratic nonsense to try to eliminate candidates for an election, and it defeats the whole purpose of a public campaign finance board to give confidence to the voters, to the donors that want to participate in New York State, not outside money, but want to participate in this process in New York State. So I totally disagree with your assessment. It was wrong. It was a misfire, and it's not about a blame game. They just didn't do it. So now you're going to try to penalize candidates, and it's not just one. You're going to penalize those candidates because they weren't informed of an emergency declaration, which was done in December with no notification to any of the candidates that they had to refile a different form. It's just absurd to try to defend this. And so, I understand how you're gonna vote. That's no surprise, but it's not a logical application of the intent of the public campaign finance program.
And I understand how you're going to vote, and that's no surprise.
Well, yeah, because it's wrong, not because I'm a Republican. It's because it's wrong. So don't sit there and pontificate to me. I have a right.
And don't pontificate to me. I think you're wrong. I think you're misstating the facts, but I think we can proceed to a vote because I think we all know how we're going to vote.
Well, I don't think you have the facts correct. The form wasn't distributed. The form wasn't communicated to the campaigns that they need to file the form. They were already accepted in the program. Those are the facts, undisputable facts. So
They
cover this
were not.
any way you want. What?
They were not. Your pronoun is wrong. They were not.
Great, wonderful.
Todd Hood
Be my English teacher
never,
next year.
has never filed anything to participate in the program. And I believe he's an essential part of the gubernatorial ticket. So they have not submitted anything. One has. There's no Bruce rule. There's a rule for the governor and the lieutenant governor. The lieutenant governor is not yet participating in the program, has made no effort to participate in the program, has had the opportunity to do so. The gubernatorial candidate amended his certification after the lieutenant governor candidate was picked. He made no effort to add the lieutenant governor candidate. He's running solo at this point in terms of the Public Campaign Finance Board. Those are the facts. That's why I'm voting against this amendment.
Commissioner, the board accepted those as a bipartisan manner.
Yeah, the candidates that had filed were already accepted by the board. And over a piece of paper that we changed in December with no notification to any of the candidates. Period.
And I think, Madam Chair,
Yes. Mr. Cassell.
it's obviously we're dealing in uncharted waters here. You keep referring to the fact that the lieutenant governor candidate didn't do this, to do that. For all intents and purposes, there is no longer a separate campaign for lieutenant governor. It's a ticket. As I understand it, the lieutenant governor candidate cannot raise money, cannot spend money, all goes through the main committee of the candidate for governor. We certified the candidate for governor. There can be no other changes. The only purpose of getting the candidate for lieutenant governor to sign the form is, I'm sure, is to ensure he's covered it under any enforcement actions, which is understandable. But it's a bureaucratic snafu. This wasn't anything intentional, nothing criminal. It was strictly a bureaucratic snafu, and we had to have the guts to correct it.
Thank you, Mr. Cassell. It's my understanding that this issue was discussed after we had a unanimous vote here on this board to change it and make clear that both the governor and lieutenant governor had to file either jointly on one form or separately. The lieutenant governor could have filed a separate form and we would have joined them and had no problem at all. And that it was acknowledged towards the end of this meeting that we did not, that the form was adequate, could be used. And so this issue of the form seems like a spurious issue here. The form was there. No one called to say, where's the form that we need? I didn't receive a call. I don't know if anyone else received a phone call saying, where's the form we need? There's just a complete lack of recognition that the regulation was changed. The statute was changed in 2025, and we followed up with this meeting and regulation and resolution. So it seems like there was quite a bit of open, transparent public process on this. I guess we could go on.
Well, whatever
Yes, we
discussion
can.
is held at the board meeting does not constitute a clear communication to any of the prospective candidates. And that should have happened by our staff, bipartisan staff, should have notified the candidates that were already approved in the program that we changed the regulation in December. We should have notified them and sent them the form to say, you need to also do this based on the emergency regulation. So the board staff, bipartisan, never reached out to the candidates and say, oh, by the way, we just changed this regulation in a December meeting that nobody knew about, other than maybe the people in this room. And that's where it fell through the cracks, is the staff should have notified the candidates that, oh, we got a new regulation you gotta follow, you gotta fill out this form, fill it out and get it to us. But that communication never existed. And I don't know about you, but I don't think there's a whole lot of people watching or listening to our conversations in our meetings. And it's awful that we're using a bureaucratic snafu to punish people that had no idea that this was changed.
Madam Chair,
Yes, Mr. Cassell.
with respect to campaign finance overall, the New York State Board of Elections has had a long history and tradition of working with candidates to get them into compliance. The purpose of these laws is not to keep them out of the campaigns, it's to bring them in under. And I think the attitude here should be, we bring everybody in, let people run, let people raise money, do what they need to do. However, when they mess up, then we go after them, and we have a tradition of doing that as well. But I think we should have an inclusive process, not an exclusive process here.
Yes, but there's certain threshold responsibilities on the part of a candidate. These are candidates for governor of the state of New York, you know? They're not.
I understand that.
The program that's.
We're not talking.
$3 million from our program, and they're not paying any attention. I'm dubious, about that argument. I'm skeptical that that's it. I wonder what's going on, with that.
We're not talking.
What's going on is we're living in uncharted waters, and we did not provide enough communication. As a matter of fact, this whole fiasco we're dealing with today only became public when a newspaper reporter broke the story. This board did nothing to notify the candidates that they had a problem.
Okay, thank you very much. I think it's been, anyone else really feel they have something new and different to add here before I call for a vote?
I'd just like to clarify what we're voting on here. As I understand it, the motion that we're voting on right now is the motion by Commissioner Kolb, seconded by Commissioner Cassell, to amend this resolution to include an action that the staff must create a form to implement this regulation before it goes into effect. That is the amendment that I believe we're now voting on.
That's correct, Peter.
Okay, I just wanted to clarify that. Okay.
That's correct, Mr. Kaczynski. Yes, so I'm calling for a vote on this amendment. All those in favor of this amendment put forward by Brian Cole.
I'm sorry, I need a recess for lack of readiness. I need a recess.
We need a recess. Sorry, recess. Little interruption. Thank you.
I'm sorry, you're taking a recess?
There seems to be a little problem.
Okay.
We have a little recess here.
Okay, go ahead.
Be with you in a moment. Thank you. To continue this meeting, we're picking up where we left off. We're voting on the amendment to the resolution. The amendment by Brian Kolb. All those in favor of this amendment, please say aye.
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 Thank you. Those opposed? No.
Nay.
The amendment has failed 4-3. Thank you. Thank you very much for the helpful discussion. Now we have the resolution. Where are we here? I've lost track. This is it. Yes. Our resolution back on 2026-06, letter C on the agenda. I'd like to take up the resolution. Again, do I have a motion on the resolution?
I think we already moved and seconded it, but I'll move it again.
Oh, right, sorry,
Second.
backing up here. So we're ready for a vote on this resolution. All those in favor of the resolution say aye.
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 All those opposed?
No.
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 The resolution has passed 4-3. Thank you. Item D on the agenda, resolution 2026-07, proposed regulation related to eligibility for the public campaign finance program for certain candidates. I'd like to take up this resolution. Do I have a motion?
So moved.
Henry has moved. A second.
Second.
Thank you, Esma. And is there any discussion on this resolution?
Yes.
Yes.
I'd like to confirm a couple things. and details of the facts and requirements of the Republican staff and Director Zeilman. And you can please confirm how many committees are affected by this decision, and if any of them were certified by a bipartisan PCFB staff.
Thank you, Commissioner. 6 committees, Mofford, New York, 2026, certified February 25th, 2025. Harry Sharp for governor, certified September 12th, 2025. Marvin Williams for governor, 2026, certified November 25th, 2025, excuse me. Blakeman for New York, certified December 17th, 2025. Ronan for governor, certified February 23rd, 2026. The New American Coalition, Democrats refused to certify even though it meets the same requirements as those mentioned above.
Were any of these committees notified about the need to file a new joint certification?
No, Commissioner.
Did the PCFB create the form necessary to facilitate a joint filing?
No.
Be in compliance with the regulation?
No, Commissioner.
Did the PCFB change the instructions on the PCF 22 form to instruct candidates on how to complete it if they were running for the new joint office of governor and lieutenant governor?
No.
Does the PCFB have an obligation to communicate with filers about upcoming deadlines or requirements?
Yes, Commissioner.
So the PCFB handbook was updated in both January and March of this year with the exact purpose of amending language based on the changes to the program enacted in 2025. Does the current PCFB handbook or any of the previous versions provide any language or instruction about the joint application certification?
No.
Do the PCFB training materials provide any language or instruction about the joint application and certification?
No.
Was communication ever sent to any gubernatorial candidates who had registered or certified in the program regarding the amended regulation?
No.
When a committee successfully registers with the PCFB, what is sent out to the committee?
We send out a welcome letter with important details that are sent to the treasurer, as well as an email to set up their account with the EFS, which is the electronic filing system software.
Did all the committees being discussed today receive the welcome letter?
Yes.
When a candidate successfully applies and is certified with the program, what is sent out?
An email is sent out directly from the committee's assigned auditor to the candidate, congratulating them on being certified in the program.
Did all the gubernatorial candidates being discussed today receive the congratulations email from the PCFB auditor?
All but one committee where the certification was received at the deadline, and this is the new standard was applied. That committee is the New American Coalition.
Does the welcome letter or the congratulations email sent to these candidates mention anything about a lieutenant governor candidate and new requirements?
No, Commissioner.
Do you have any examples of other outreach PCFB has done to participants in the program?
The PCFB uses phone calls, its website, direct and blast emails. We've used social media to post communications with participants in the public. I'll share with you some examples that we have sent out to participants. Confirmation of registration and application certification, reminders for required campaign finance disclosure, reporting deadlines, announcing training schedules for training treasurers and candidates, reminders about setting up vendor accounts to receive public matching fund payments, eligibility status reports as candidates seek to hit fundraising thresholds, issues found in disclosure reports that need to be corrected. We also send out reminders to submit bank statements and other documents. And finally, we reach out to candidates when their forms are deemed insufficient.
Do you have any examples of outreach PCFB has done to non-participants?
Yes, Commissioner. Specifically, February 5th, 2026, the PCFB sent an email to all authorized committees for candidates for statewide and state legislative offices, including Governor Hochul, who had not yet chosen to participate in the program, reminding them that the program exists and instructing them how to register and certify before the February 23rd.
Is there a process by which PCFB employees reach out to individuals who have submitted forms if something is missing or incorrect? And how does a form get corrected?
PCFB staff has been instructed by bipartisan leadership to be helpful to those seeking to register and or certify. PCFB staff frequently makes phone calls and send emails to obtain missing, incomplete, or incorrect information on the PCF 21 and PCF 22 forms.
Were any of these forms for any of these committees initially rejected for non-compliance related to other issues with the forms?
Yes, Commissioner, Ronan for Governor had its form initially rejected prior to the deadline for non-compliance.
When this form and others are rejected, are they sent any communication regarding it?
Yes, Ronan for Governor was sent a rejection letter along with detailed information on how to submit a complete form.
Did that rejection letter state anything regarding the need for a joint filing in order for the form to be considered complete?
No, it did not.
So when they refiled the form based on the instructions given, was it accepted by a bipartisan team?
Yes, Commissioner.
The mission statement of the PCFB is responsible for developing a program for informing candidates and the public as to the purpose and effect of the program, including the preparation and dissemination of educational materials, providing compliance counseling and guidance to candidates seeking to participate in the program. By the acts of registering and certifying the program, these gubernatorial candidates clearly show they were seeking to participate in the program. Doesn't the PCFB have an obligation to provide compliance counseling and guidance to them? Doesn't the PCFB have an obligation to disseminate the educational materials about the change to the governor and lieutenant governor ticket?
Commissioner, the PCFB did have an obligation to be communicative about this change and failed to do so adequately in this instance. It is unreasonable to hold candidates liable for an obvious error on the board.
So to be clear, our bipartisan PCFB staff failed to notify anyone of the change in the educational materials. It failed to communicate to candidates already registered of the change. It failed to communicate with candidates not registered of the change. It failed to publish the change in the handbook or in the training materials. It failed to create the joint form as required. PCFB staff created an internal workaround, which is a violation of the regulation, and failed to communicate that as an option. It never updated so much as the instructions on the form. Instead of holding anyone inside the building responsible for the failures of the board, we're going to decide to blame the one group that should objectively be held harmless, the participants, who in almost every case were told they were in the program. We told them they were certified. Now half of the board staff wants to make up a procedure to decertify candidates from the program. This fact pattern flies directly in the face of the mission statement of the board and past practice. Playing gotcha politics with this is frankly disgraceful. If the board has any sense at all, it would unanimously vote to reject this motion.
Thank you, Brian. Thank you, Brian Keegan.
Thank you. I heard a lot of questions there. I didn't hear the one that I think is the most important before us, and that is, did candidate Hood file anything? Because the answer, I think we all agree, is no. And for governor and lieutenant governor, the law does not treat the candidates as two unrelated individuals who happen to be running in the same election cycle. It treats them as a joint candidacy for the purposes that matter most here. Election law establishes a combined threshold for eligibility, it establishes combined public funds caps, requires that both candidates running jointly for governor and lieutenant governor jointly submit an application and certification. This is not a technicality. It's how the board knows who is applying, who is agreeing to participate, and who is bound by the program's conditions, who is associated with the committee for compliance purposes, and who may lawfully receive or trigger the disbursement of public money. This program distributes taxpayer funds. It is not enough for the board to infer eligibility, assume participation, or reconstruct compliance after the fact. The board has to know, and it has to know from the record before it. If the law requires two people to apply jointly and only one has done so in any meaningful sense, then the board does not have a joint application. It has something short of what the law requires. And something short of what the law requires is not a lawful basis for certification. It's important not to blur two separate ideas. The first is that the board may sometimes process filings administratively in a practical way. That's true. Democrat and Republican councils agreed that if the board received separate sets of forms from each candidate, those filings could be merged administratively. Likewise, if the board received one set of documents naming both candidates with attached pages or signatures and initials, those too could be processed as a joint submission. But that is not what happened. This is not a case where the board received the required materials in a form that needs tidying up. This is a case where, as to the lieutenant governor candidate, the board did not receive the required materials at all. That leads to the first major reason these committees should not be certified. The board has no legal basis to conclude that the joint candidacy actually applied to participate in the public financing program. Certification is the gateway into a legal regime. By applying, candidates affirmatively agree to be bound by obligations that do not apply in the same way to non-participating candidates, including disclosure requirements, audit requirements, record-keeping requirements, and possible repayment and enforcement consequences. Those obligations do not hover over a campaign in the abstract. They attach to actual candidates. If one of the two members of a legally required joint filing has never submitted the required paperwork, then the board has no adequate basis to conclude that the ticket, as a ticket, has entered the program on the terms the law requires. And for governor and lieutenant governor, the ticket is the relevant unit for these purposes. Second, these committees should not be certified because the board cannot properly assess eligibility without complete candidate identification and participation. One of our central responsibilities is to determine whether a candidate is entitled to public money at all. That requires more than just counting contributions. A candidate must be on the ballot within applicable self-funding limits, current on obligations, and otherwise compliant with the governing statutory and regulatory framework. Those are candidate-specific determinations. They cannot be responsibly made about a person who has not properly appeared before the board through the required filing structure. And public financing is not only about initial disbursement of funds, it's also about everything that follows. The board reviews disclosure statements, it reassesses eligibility. After later filings, it conducts audits. It may require repayment of improperly spent or surplus public funds. It may impose penalties. In serious cases, it may refer matters for criminal enforcement. None of that works unless the board has a proper record of who exactly is participating in the program as a candidate. The board needs names, signatures, certifications, commitments, and a clear record establishing who is in the program and on what basis. In the end, this case, it's not complicated. The law links governor and lieutenant governor for public financing purposes. The regulation requires both candidates running jointly to jointly submit an application and certification. They could do that on one form, they could do it on two separate forms. But as everyone here agreed, and I believe there was discussion that made this abundantly clear, they both need to file. That requirement was publicly adopted, publicly known, and in place for months. The board did not receive the required filing from the lieutenant governor candidate. The board therefore does not have the joint submission the law requires.
Thank you, Brian. Any other discussion here on this resolution?
Yeah, Commissioner, if I could just make a
Because it's-
comment. Thank you. I just wanted to reiterate what I believe Commissioner Kolb alluded to, and I agree entirely with him. I've been on this board for, I think, longer than anybody. I've never seen a situation where we have potentially using the raw power of this particular board to disenfranchise a candidate and its voters. You know, we have two boards here. The State Board of Elections has two Republicans, two Democrats. It's equal representation just to avoid this kind of gamesmanship. Unfortunately, I guess this board has a 4-3 makeup, 4 Democrats and 3 Republicans. and it allows the Democratic majority to ram things through regardless of the facts. I think Commissioner Kolb outlined adequately how the staff and arguably the board failed the candidates numerous times. There was no opportunity for the candidate to be aware of this regulation, of this requirement. The bureaucratic explanation I just heard from the staff about why we should adopt this resolution just goes to why we even have a board. This board here is to make things right when the staff goes wrong. And the staff has gone wrong here, not only in their conclusion, but in the way they handled the whole situation. Their failure to promulgate this regulation, their failure to communicate this to not just one candidate, but several candidates. We're not just talking about a single candidate here. We're talking about 6 different candidates who are affected by this, 6 different candidates who are unaware of this regulation and thus failed to comply. So this isn't one candidate. This is the majority, as it turns out, of the candidates that applied. And yet, the staff sees it as their job to just blindly follow something. I think it's this board's obligation to put some reason into this, some rationale into this, and to realize we failed the candidates. We failed the system. We need to make it right.
Thank you, Mr. Kaczynski. Any further discussion on this resolution? Mr. Berger?
Yeah, I've got a couple, I don't know, they're problems, concerns, issues with where we are, but I start with what our jurisdiction is and what we are as a board. We're a ministerial board. Our job is not to create policy, but to apply the law and the regulations as they exist and as they have existed. This issue came up at the December 9th meeting. At the end of the meeting, there was a discussion in response to a question by one of the commissioners, what do you do about a lieutenant governor candidate? And there was a discussion and explanation about it. I would hope that the campaign of a candidate for governor for the state of New York would make themselves aware of what laws apply to them as we do in so many other areas. But my issues are 2. 1, the regulation provides to be eligible to receive funds, both candidates running jointly for governor and lieutenant governor shall jointly submit an application certification. It requires both candidates to do it. That hasn't happened here. The implications of that, though, are significant. One of the candidates, the candidate for lieutenant governor, has made no effort to join the program. By filing a certification, either individually, which we permitted, or jointly, that candidate agrees to be subject to all the rules and regulations of the board. One of the candidates hasn't done that. And there's only one who hasn't done that. One of the candidates hasn't done that. We cannot provide funds to a candidate who hasn't agreed to be bound by the rules and regulations. No matter where we were today, we couldn't send out a check to Todd Hood, to Todd Hood's campaign, even though it's a joint campaign with the governor. He's on that. He's got an existing political committee. He's got a committee for sheriff. We don't know what that, as a PCFB, we don't know what that committee is doing, and he hasn't agreed to limit the actions of that committee to what would be permitted as a candidate for lieutenant governor. So since he has never filed the certification as required, and since he has not agreed to be bound by the rules and regulations, and he's had plenty of time to do it, we just cannot agree to send them money. I could go on, there are so many other issues, but those are the 2 main things. We're ministerial, we apply the rules, they haven't complied in a substantive manner, which puts our program at risk. And as a matter of the integrity of the program, we can't create special rules for individual favored candidates. We have to apply the rules as they exist equally to all campaigns. And once we start fudging rules for one candidate, you know, we have created huge ongoing problems for ourselves. So that's where I am on this. I don't think it's any surprise. And, I thank everybody for their attention. I know I've gone on too long.
Thank you, Mr. Berger.
Madam Chair, if I may.
Yes, Mr. Zeilman, and then Mr. Cassell is
Thank
there
you.
as well.
PCFB, we have a cure provision. And we never offered this candidate or any of the candidates an opportunity to cure what was submitted. So I think now is the time that we do that, and we can do that today.
Mr. Cassell?
Yeah, thank you. From what I've heard today, I don't believe that we would be doing a disservice to this program by adopting this resolution. The candidates would not benefit, the public would not benefit. From what I can see, the only person who benefits from this action today is the governor. And it's very convenient that following her decision in February to not participate in the program, all of a sudden, Democrat staff members decide to block every other candidate. By the way, there's 6 of them, not just the one you keep referring to. And there's another lieutenant governor candidate been announced. Now, whether they file or not is another question, but potentially could have another lieutenant governor candidate who was named lieutenant governor candidate after the deadline. So there's, and I don't understand how a candidate for lieutenant governor could file a form that doesn't exist. That's the issue. But the message to New Yorkers today is very clear. We're only interested in releasing public dollars to campaigns when the governor is comfortable with it. I find the governor's spokesman's recent remarks to the press indicating that the governor is, quote, proud to decline taxpayer dollars and feels those dollars could be better spent elsewhere, very interesting. I also find it highly hypocritical. This is her program. She's been one of its biggest proponents. In 2023, in her own words, when she acted on a piece of legislation, she said, quote, public campaign finance laws were written to amplify the voice of low-dollar donors and, quote, diversify the pool of candidates who can run for office. I guess she was for it until she wasn't. When the program was created in 2020, the state legislature declared the high cost of running for office in New York discourages qualified candidates from running for office and creates an electoral system that encourages candidates to spend too much time raising money. They also found that the system of voluntary public financing furthers the government's interest in encouraging qualified candidates to run for office. Commissioner Lifton, I'm sure you're well aware of this rationale for creating the program because you voted for it on April 3rd, 2020. As a matter of fact, you voted to create the very position you now hold. In my view, we would be doing the taxpayers of the state a great disservice by disqualifying any candidate from this program solely on the basis of a bureaucratic error, not of their own making.
Thank you, Mr. Cassell. Yes, Commissioner Gaskins Nathan.
I find myself frustrated by the situation. I don't believe that the board was formed, this program was formed. It was formed to be inclusive of voters, not assured for partisan action. However, I think the framing of this debate is also equally disingenuous and problematic. As for the governor, it's not her program, it's a voters program. And as a consequence, as much as we want to engage around this sort of gamesmanship, the way this is evolving, the fact is there was no formed file. There's nothing to cure because you can't cure something that doesn't exist. And I'm sorry? I think I was speaking. Do you have something?
No.
And while I am disappointed in the outcome, for the sake of the candidates and the candidates and the voters that may want to participate in the program, we have an obligation to run the program appropriately and in compliance with the law for the sake of the voters and protection of taxpayer dollars. That's what the program is for. We cannot abandon it when we have candidates we like more or less than others, nor should this be considered the province of any politician that voted or didn't vote for it. This is a province of the voters, and we are stewards of that honor and responsibility. And in this case, the suggestion that we can simply ignore the rules and the parameters when some candidates were able to comply, there was a process that was discussed at the meeting that all parties were here. And to your point, that was made earlier, it is a bipartisan. There is opportunities to pretend there was no opportunity. And to sit here today, to my knowledge, there has still not been a form filed by any of these candidates to actually participate in the program. Is that correct? And they've had every opportunity to do so, so we had something to act on. So we could cure something. There's nothing. And then to turn around and say somehow we're undermining the interests of the voters by refusing to act arbitrarily based on political self-interest, I think is disingenuous to its core. There is no question this is a disappointing outcome. But we are obligated to execute under this program, under the way it was passed by law, the responsibility of this committee, and to work on compliance. But I feel the candidates themselves have failed to actually do anything to allow us to move forward and to act in a way that is consistent with their request for alternative and equitable relief, while ignoring the rules that are clearly stated that apply, frankly, to everybody. In the same way, forgive me, that I wasn't allowed to play soccer when I was 10 years old because I didn't get my form in on time and my mother told me you can't play because you didn't comply. They're running for very serious office, and I take this position very seriously. This is not an easy conversation. I hate the idea of candidates being excluded from the program for a ministerial failure, but this is not a ministerial failure. This is a complete failure of compliance, a complete failure of documentation that has given staff no opportunity to act, and at no point did the candidates themselves step forward to engage on these questions. So I'm sorry, I just needed to say that because I did find a lot of frustration in this conversation.
Brian, did you want to speak now? I just want to make one little point. Peter is a former high school English teacher. I do want to say disenfranchisement is a very strong word. It means, not able to vote. And obviously we are not disenfranchising anyone here. All these candidates are able to compete, be on the ballot, and go out and raise money in the traditional ways that have been very effective for lots of candidates around the state of New York, especially in gubernatorial races, and to have people vote for them and support them. So I don't accept that word at all, disenfranchisement. We are not disenfranchising anyone. Okay, thank you. Any further discussion?
I'm
Brian?
just curious, again, I'll direct this to Carl. Has there been any feedback from advocacy groups on this issue we're talking about?
Yes, Commissioner, both reInvent Albany and Citizens Union sent out releases calling for the board to reject a vote to decertify previously certified gubernatorial candidates because of a minor technical error that was not communicated to them. reInvent Albany called the move small-minded, quote, small-minded and highly partisan, end quote, and encouraged commissioners to vote for principles over partisanship. Citizens Union cautioned that the board members should not allow this matter to devolve into a partisan, political, and legal battle that undermines the public campaign finance program. Both groups strongly recommend that candidates should be allowed to cure the forms and participate in the program. Anything else would cause great damage to the program.
And also, didn't Brennan Center weigh in
Yes, sir.
as well?
They did.
Okay. So, one final question is really before we vote, EL 14-207 outlines that the makeup of the Public Campaign Finance Board shall include the 4 current state board commissioners, as well as 3 other commissioners, each with direct and separate appointing authorities. My appointment as vice chair of the PCFB came as a joint appointment from the legislative authority. Our colleague, Commissioner Gaskins Nathan, appointment came as a joint appointment from the legislative majority. Your appointment, Chairman or Chairwoman Lifton, singularly came from the governor's office. In fact, November 3rd, 2022, a press release announcing your appointment as the chair of the PCFB can be seen on the PCFB's website even today in notes. Barbara Lifton was appointed by New York State Governor Kathy Hochul. And I think for the record to note, I think there's a conflict of interest because Governor Hochul will benefit from knocking out 6 candidates moved by this board. And I think that you should recuse yourself and abstain because I'm pretty safe to say you will be the deciding vote with the other members. So I think it's a conflict of interest. The person that appointed you directly benefits by knocking all 6 candidates out on a form that they weren't informed of. And they're supposed to, I guarantee you, there's so many laws in this state that are passed and agencies that do things. Nobody tells the public in general what's going on. And then say, oh, you didn't know this? This is your fault. It's our responsibility to notify candidates or prospective candidates if something changed, which it did in December of 2025. And I think and this shouldn't be about partisan stuff. It should be about, we want candidates to be in the program. We as an entire staff and board didn't notify the candidates. And even from the point you're making about Mr. Hood, well, did anybody notify him that he's got to file a form? I don't think so. And it just reeks, this whole process, and it is political because you're punishing the 6 candidates that are trying to run for governor. Whether any of them will be successful, I don't know. But the point is, okay, Mr. Hood, you didn't file a form. You've got to with Mr. Blake. Well, did anybody communicate that to him? No. Oh, he forgot to do it. Well, maybe he didn't know he had to do it. I mean, that's the problem. That's what the PCFB staff does on a regular basis. They audit forms for submittal. They audit for payments. We go back and check to make sure the donations are legal. And for those that aren't or out of place, we do enforcement actions. But yet, we can't notify anybody, or we notify everybody about everything else. But this one example with the gubernatorial candidates, and I want to say this again, it's about 6, not 1. In disenfranchising, it is disenfranchising those 6 candidates out of this program, which all I'm saying is they should have had an opportunity to cure or get the form in, and we should have, as a staff, informed them before the deadline came and went. And Barbara, this isn't personal at all, but I really think it is a conflict of interest for you to vote on this because you directly were appointed by Governor Hochul, who will benefit by these 6 candidates not being qualified. So but I just want you to know.
Madam Chair, could I just make a point for the record?
Yes.
It is 5 candidates because one candidate actually submitted, another one did it for the 7. One did it for both. The other one on this list submitted for both, but submitted it late. So it's being ruled off really for lateness. So they're not 6 people that are similarly situated.
If I can just respond to that, well, the second duplicate filing for Lieutenant Governor did come in after the fact. I'd like to point out that it wasn't until that candidate called after the deadline to ask if there was anything else they needed to do that they were informed by PCFB staff on the Tuesday after the deadline that this is something they needed to do, which is why it was late. So again, it was a scenario where
Would that one be eligible for cure? I don't think so, right? There's still a delay problem, right?
The other thing is just as in ballot access, do we accept filings over the counter? Yes. Are they valid at that moment? Yes. In the case of the PCFB, they still have to hit their thresholds. They still have to hit ballot access, right? Just as in a petition where there may be objections, specifications to objections that have to be reviewed. Ministerial agency, so.
And if I can, in those scenarios, we provide a process and we're open about what candidates need to do. And I mean, if we're going to take petitions, for an example, when specs are filed, we have a hearing with the candidates present, right? And we've given no notification. To this day, we have not told a single one of these campaigns that they've done anything wrong. only reason why they know about it is because it was printed in a newspaper. We still haven't told them they did anything wrong. And it won't be until a board determines at this meeting that they'll even be notified that there is a problem officially by this agency.
And to your point, the only way that we know that there's Hood is running with Blakeman, it's because of the newspaper.
I don't, so
Right.
I fundamentally, I respectfully disagree with that. Eligibility of candidates, part of that is ballot access, which means the PCFB is required to take a look at what's filed to ensure that participants to receive money have been in the program. In the one instance you keep bringing up, and again, respectfully, there are 6, not 1, but in the one instance you keep bringing up, there was a filing at this agency that clearly tied the 2 candidates together. So by that logic, this board had notification that there was a joint ticket because it was filed in this agency. And by that logic, staff should have taken that opportunity to look at the official document filed with the board and reached out. If we're gonna use we absolutely did know. They filed a piece of paper with the state board.
And the piece of paper that they filed with the state board was not a new form. It was this product of a new piece of law that no one told any of the candidates about. Yet somehow they were able to figure out how to file a joint ballot access ticket, which if they had not done correctly, they also wouldn't know until we had a ballot access determination and then it would be deemed invalid.
Fair, but I'd also like to point out the fact that there's a fundamental difference between law, which is passed by the legislature, published for 3 days, and given out copies and passed, which this was done in the budget, and the requirement for a joint filing. We keep saying it's in the law. To be clear, it's not in the law. It wasn't passed in the budget bill. It was passed in a regulation by this board.
Unanimous.
Unanimously.
I'm sure, but it was passed by a regulation by the board. I'm not asperging blame on one side or the other. My position is that we failed. As an agency, we failed. Not that one side failed, the other side didn't. We failed. We had an obligation to do outreach and we just didn't do it. And I just think we should do it. But look, I've made my point, you've made your points. We're obviously not going to agree on this. You know, we have a very different opinion on the course ahead for these candidates, all 6.
I will speak to your question, your request, Mr. Cole. You know, I've been in politics I was in politics and as chief of staff to my predecessor for 14 years, 18 years in the New York State Assembly, and now I think 3 years here. And no one has ever questioned my honesty or my integrity. And you aren't either. I understand you're saying it's not personal, so I assume you're not questioning my honesty or integrity.
Nope.
And so I had no discussions, no pressure, no phone calls. Frankly, I really wasn't paying attention to this, honestly, who was going to benefit or not benefit. I was looking, I think as all of us here were looking at what is the law, what is the regulation, what are candidates supposed to do? That was the only thing that's the only thing I have or will consider on this, you know, and this whole matter. It's just, it's not the case that I have been influenced by what you're inferring on the political side of this.
Not inferring anything. I'm just saying that you were appointed by the governor. The governor benefits by your vote. And that is the only thing I'm saying, you know, in terms of conflict of interest. It's not, and I don't accuse you of doing anything other than you're a direct appointee of the governor. And the governor is going to benefit by your vote on this resolution. And it's, like I said, I don't think you're doing anything wrong. I think you're honest. I'm just suggesting that it's a conflict of interest to vote on something that is going to directly benefit the person that appointed you to the board.
I understand the appearance issue. I've taken the same ethics training that you've taken. But I do think this is too important to vote to just say I'm gonna bow out of this vote. I think that would be irresponsible of me to do that. And but I appreciate the opportunity to make my position in that clear, Mr. Cole.
Madam Chair,
And yes, Mr. Berger.
I am concerned about one area where these comments have gone, and that is to try to impose on the staff the blame for the situation we're in today. In a prior life, I spent more than 50 years advising candidates and campaigns in their campaigns. And it was our obligation as a campaign and my obligation as an attorney for the campaign to know what the laws were that applied to us and make sure we complied with those laws. It wasn't up to the agencies to tell us what to do. We had that obligation. And to try to impose on the staff, the bipartisan staff, the failure of this campaign to comply, I think, is unfair to the staff, and we ought not be doing it. The blame rests clearly where it is. Thank you.
Thank you, Mr. Berger.
Henry, I'm just gonna respond to that for a minute because I worked at the Board of Elections for a long time. And you know, I worked there for many years, and we do have an obligation to work with candidates. We always had an obligation to work with candidates. And if candidates had questions, we answered them. My understanding in this situation is there were numerous communications between our staff and these different candidates. However, not once did the staff bring up this particular issue. Do I think there's a responsibility for the staff to communicate with candidates? Absolutely. Do I think that the candidates reached out to us and were communicating with us and we failed on our part? Absolutely. So I'm not in favor of throwing staff in. I will tell you that I'm also not in favor of making victims of candidates who are not apprised of the state of the law in a proper way. And I think that has been pointed out, this is a regulation of the board. It is not a state statute. It is a regulation of the board. Thus, the board has complete control over this. So this implication that we cannot make an exception is just not true. This is our regulation. This is not the state legislature that we're trying to override some way as an administrative agency. This was an administrative regulation that we adopted and that we have total control over. So if we wanted to realize it was improperly implemented, which it was, and thus we should not enforce it, we certainly have that right. In fact, I would assert we have that obligation.
Madam Chair.
Mr. Casal, maybe one last comment if we could make this. Maybe.
I appreciate your comments and your concerns, Mr. Berger, but you can imagine the past 58 years, I've worked on a couple of campaigns as well, federal, state, and local. And I know it's the obligation of the campaign to know the law and to proceed, but when the law keeps changing, when the goalposts keep getting moved, this is all brand new, uncharted waters. The very first concept of running as a ticket instead of separate primary, the concept of this new form that doesn't exist. I'm going to keep pointing out what form do you follow when one doesn't exist, coupled with the tradition of the Board of Elections. And I've been both a victim and a beneficiary of the Board of Elections decisions over the years. I can tell you the board has always tried to help people get into compliance. And has been pointed out, where do you find this regulation other than as a proposed regulation for comment period? I understand they should have known, we should have known, but we did know and they didn't know and we didn't tell them. And that's the bottom line here. Somebody held back. Somebody held back someplace, and that's the issue. And I don't think you penalize the campaign because we don't communicate properly. It's not in the handbook. It's not in the instructions. And the form doesn't exist. We said promulgate a form. It did not get produced. There is no form. Yes, an internal decision was made that if two people file separate forms, we can marry them here at the board. But was that communicated? I'm not sure. There's no form. I appreciate very much what you're saying. I understand it's the campaign's obligation to know the law. But the law keeps changing, the rules keep changing. This isn't even a law, it's a regulation that isn't even adopted fully yet. So please, I understand what you're saying, but let's kind of go halfway here with people. This should be a process of inclusion, not exclusion. If this board's job is to exclude people from running, to exclude people from getting public financing, then we shouldn't be a board to begin with.
Henry, you're all set? Any other discussion before we call the question here? Thank you all very much for the discussion. I'd like to take this resolution up. Do I have a motion?
So moved.
The second. Yes, thank you. Time for vote on this resolution. All those in favor of resolution 2026-07, please say aye.
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 All opposed?
No.
No.
Nay.
Resolution passes 4-3. Thank you all very much. Sorry. We'll be scheduling a meeting later. There's no meeting scheduled at this moment. Is there a motion to adjourn our meeting? Thank you. A second.
Second.
Thank you. All those in favor of adjourning the meeting, say aye.
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 Any opposed? Thank you all very much. Meeting's adjourned.